We expand now by joined by Judges Matter Research Advocacy Officer Mbekezeli Benjamin. A very good evening to you, Mbekezeli. Thank you so much for your time. A case that has been dragging on for several years now, as we listen to testament today that Makhubele has been called an unsatisfactory witness in terms of giving evidence. How should that be interpreted?
Good evening, Paul, and good evening to the viewers. Yes, the evidence leaders were arguing today that Judge Makhubele was an unsatisfactory witness. So they are essentially trying to discredit her credibility as a witness, because in these tribunal proceedings, she is essentially being investigated for her conduct. And there were about 4 or 5 witnesses who testified against her, and she was the only witness who testified in her own favor. And so the evidence leaders are trying to put her evidence against the evidence of the other witnesses, to say that she wasn't a satisfactory witness when it comes to the allegations against her. And for that, and for the reasons put forward in the complaints and the evidence that was heard by the tribunal, then she should be found guilty of gross misconduct.
She was the first and only judge to appear before the Zondo Commission. What should be made of the merits of this case, as her credibility is under the spotlight?
Yes, this case is actually important also in that respect. You'll recall that Judge Makhubele was the only judge to appear before the Zondo Commission while it was doing its investigations. And the Zondo Commission actually recommended that they will not continue with the investigation in relation to her, but they know that the tribunal will continue with the investigation, because already by the time of the Zondo Commission, the complaint had already been filed by Unite Behind against Judge Makhubele. And so the tribunal proceedings would be the ones that go into more detail to find out exactly what she did while she was at PRASA. Because, like you said in your introduction, she was accused of allegedly furthering state capture and corruption while chairperson of PRASA. And part of the testimony that came through, at least 4 or 5 of the witnesses, was that while she was at PRASA, she was very involved in the affairs of the company, to the point where she got involved in one of the cases, and she sidelined the legal department of PRASA. And in that process, she managed to secure settlement agreements against a company that had been it was said to have concluded the contracts with PRASA illegally or through corrupt means. And so the argument is that while she was there, she furthered this corruption by this company. Of course, she denies these allegations, and tomorrow she will, and her team will respond to some of the arguments from the legal, the evidence leaders. But certainly today, the picture that was painted was that firstly, she simply took up this role months before she was supposed to be a permanent judge of the High Court. And while she was in the role, she zoomed in on a specific case and a specific transaction to the detriment of PRASA. And so they're trying to say that through her conduct and through her actions, she made it very clear that she is unfit to be a judge and she should be removed as a judge.
We listened to evidence leader Dorian Paver saying and emphasizing that a judge is not an employee. How significant is that in the bigger scheme of this matter?
Well, it is quite significant, because the argument that Judge Makhubele and her legal team make is that she wasn't actually formally appointed as a judge. They argue that on normal employment principles, when you are an employee, a company makes an offer to you and you will accept the terms, or you will renegotiate the terms. And ultimately that negotiation will lead to a contract being concluded, and then you will officially be appointed in that company. And they're making the comparison with how, when Judge Makhubele was offered, they say that President Zuma essentially offered her the role of a judge. And she said, no, I don't want to start on the 1st of January. I want to start on the 1st of June. that negotiation process was akin to the employment context, or the what usually happens in other employment contracts. So they are essentially saying that she didn't take up the appointment, or she wasn't effectively appointed from the 1st of June. So it wasn't possible for her to be both a judge and a chairperson of PRASA. And so the argument that the evidence leaders were making, and also the complainants, was that no, you can't look at the appointment of a judge in the same way that you would look at the normal employment context. Yeah. Judges are not employees. They are constitutional office bearers, and the appointment of a judge is a constitutional process which is undertaken by the JSC and the president. So there is no renegotiation. And so it couldn't be that when President Zuma made the decision to appoint Judge Makhubele from the 1st of January 2018, there was still room for any negotiation, because it wasn't a normal employment context. Judges are not employees. So that is what the argument was showing.
Very well. Thank you so much for expanding on this, clarifying that Judges Matter Research and Advocacy Officer Mbekezeli Benjamin, giving us a sense there of the dynamics around Judge Makhubele's matter.